This video examines 3 separate probable cause proceedings that occurred in Judge David Fleischer's courtroom at the Harris County Criminal Court located in Houston, Texas. We've explored probable cause before, but to give you context in case you haven't seen it, probable cause proceedings are judicial hearings conducted shortly following an individual's arrest, particularly in cases where no warrant was issued prior to the arrest. According to Texas Code of Criminal Procedure Article 15.17, law enforcement must bring the arrested person before a magistrate promptly and without undue delay. During this hearing, the magistrate advises the defendant of their legal rights and evaluates the evidence provided by police to assess whether sufficient probable cause exists to support a belief that the person committed the alleged crime. If the magistrate determines that the arrest lacked probable cause, the defendant is required to be released from custody. Our first probable cause hearing took place on November 26, 2024, after defendant Michael Dwayne Hardy was charged with possession of marijuana on November 22, 2024.
Good morning, Mr. Hardy.
Good morning. How you doing?
Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and 1 blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, 1 red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and 2 clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed 1 burnt marijuana cigar behind the front passenger seat and 1 small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Yeah.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana.
Oh, but because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she
Mm-mm.
approached first.
What time of day or night was this?
Trying to see that, Your Honor, in a second. It's at 4 in the morning,
And Your Honor, I
4 in the
found,
morning.
4:30 a.m.
And you can delineate at 4 in the morning that parking 18 inches from a curb.
and I found the regulation, the statute in the
Mm-mm.
transportation code where it says you have to park within 18 inches.
At 4 in the morning, you can tell.
Your Honor, the officer was,
Yeah.
yes.
I don't think so. All right, I'm gonna find no probable cause.
Yes,
All
Judge.
Guys, be careful, right? You know, they're always out there. Just be careful, do something with your life. Knowledge is power. Get into school, get an education, do something with your life. Life is hard as it is. And it only gets more difficult the older you get, all right? Okay, guys, please.
Judge Fleischer found no probable cause for the arrest, ruling that the police officers lacked the necessary reasonable suspicion to initiate the stop of the defendant's vehicle in the first place. Under Texas Health and Safety Code 481.121, possession of marijuana is a Class B misdemeanor if the amount possessed is 2 ounces or less. In Mr. Hardy's case, the possession was 1.9 ounces. However, for that evidence to be admissible, the initial police encounter must be lawful under the Fourth Amendment. Here, the justification for the stop was limited to an alleged violation of Texas Transportation Code 545.303, Additional Parking Regulations. This statute mandates that an operator who stops or parks on a two-way roadway shall do so with the right-hand wheels of the vehicle parallel to and within 18 inches of the right-hand curb or edge of the roadway. Judge Fleischer determined there was insufficient evidence to support this violation. According to him, it would be very improbable for officers to visually estimate such a precise measurement from their vantage point, meaning they lacked specific, articulable facts to justify the detention. Consequently, under the fruit of the poisonous tree doctrine, codified in Texas under Article 38.23 of the Code of Criminal Procedure, any evidence gathered during this unlawful stop was deemed inadmissible. Because the basis for the police approach was invalid, Judge Fleischer concluded there was no probable cause for the arrest, and the state was forced to dismiss the charge. The next probable cause hearing we will review occurred on January 13, 2025. Defendant Leonard Sarmiento was charged on January 5, 2025 with criminal trespass in violation of Section 30.05 of the Texas Penal Code, which makes it a misdemeanor offense for a person to enter or remain on property without effective consent when they had noticed that entry was forbidden or received notice to depart but failed to do so.
Good morning, Mr. Sarmiento.
Ese señor Sarmiento.
You were,
Bien, señor Sarmiento.
you were charged with criminal trespass. You were facing up to 6 months in jail and or a $2,000 fine.
Dólares de
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
multa. Si no puede ocupar uno.
Yes, Judge.
I'm going to go slow.
Yes, Judge.
Más escucho.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
In Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know, he didn't say he know he's stolen. He just didn't know him, did not give permission.
You're telling me that he's in a car, he doesn't know the driver, and
Right, the
Su señoría,
complainant just
el
said that
quejante nomás dijo
in
de
regard, he did not know the
que
defendant, did not give a
I
permission.
understand that. I get that,
Yes.
but so he's he's a passenger in a car and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So
él manejando.
how would he even know that the car is stolen? How do they know each other? How I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey, man, you know,
Un aviso.
um,
So the trespass was the driver driving into the area and he was the defendant.
he's the passenger, right? I would assume that the driver got charged with UUMB.
Let me see what he got charged with.
Tuvo un caso.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
In Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was, one moment,
Un momento.
a scratch on the hood.
signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. That, and then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. But I thought you also said that the driver and
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
so there's enough there that a reasonable person would believe
That the,
he's in a stolen car.
Stolen, yes.
So the steering column, was it?
was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
Un desarmador podía apagar el vehículo.
See, I don't know, you know, because when I was young and dumb and 17, and, you know, my friend had a CJ7, you know, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
Judge.
always broke down. They always had a problem. We always, you know, Jimmy rigged it as well, you know?
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
That makes no difference to me.
That goes to the element of without, for the criminal trespass, it goes to with knowledge that it was
Nah, I'm not, no, I'm sorry. I'm gonna find no probable cause.
Yes,
Igual que no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world, if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir.
Judge Fleischer found no probable cause, ruling that the state failed to establish that Mr. Sarmiento knowingly entered a vehicle that he knew was stolen. To sustain a charge of criminal trespass, the state must prove that the individual entered or remained in the property without effective consent and had noticed that such entry was forbidden. In the context of a passenger, this requires proof of a culpable mental state, specifically that the defendant actually knew the car was stolen. As established in the Supreme Court ruling Ibarra versus Illinois, a person's mere propinquity to others independently suspected of criminal activity does not, without more, give rise to probable cause. In this case, the prosecution relied on the visible damage to the steering column and the use of a screwdriver to start the engine. While these facts certainly implicate the driver, they do not automatically impute knowledge to the passenger. Mere presence at the scene of a crime is insufficient to support a conviction or probable cause. The state failed to provide affirmative links demonstrating that Mr. Sarmiento, from his position in the car, observed these signs of theft or participated in the act. Accordingly, Judge Fleischer determined that the police observations were too conclusory to satisfy the burden of proof. Without specific articulable facts showing Mr. Sarmiento possessed the requisite knowledge, the element of intent was missing. Consequently, the court found no probable cause, and the charge against the passenger was dismissed. The final probable cause hearing in today's video occurred on August the 2024. Defendant Roberto Alejandro Salinas was charged on August 6, 2024, with theft in violation of Section 31.03 of the Texas Penal Code. This statute defines the offense with the unlawful appropriation of property with the intent to deprive the owner.
Good morning, Mr. Salinas. Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 23rd, 2023, the complainant made a report that his scooter was stolen and it was worth approximately $600. The complainant provided the serial number. On August 5th, 2024, the officer received a hit from Leads Online, which noted that the defendant pawned the scooter. The officer went to that Easy Pawn location at 12303 Bel Air and met with the complainant, who stated that the defendant pawned the scooter for $100. The complainant was able to provide the officer with the defendant's driver's license, and surveillance video showed that the identity of the defendant matched the video.
Yeah,
The
but
driver's
you know that
license.
he took the scooter from the place, from wherever it was, how do we know that someone didn't give it to him? I get it that he's pawned. I mean, perhaps, possession of stolen property, but theft.
So the allegation is the complainant is not the owner of the scooter, it's a pawn shop. So the allegation here is that the defendant,
Well, he's charged with theft, right? So he has to steal it.
by acquiring or accessory. Oh,
Right? You have to acquire.
yes, Your Honor. I'm reading
So
the-
here, all he's doing is he's pawning it.
Ramsey?
It's a specific intent crime, so we have to,
The intent to deprive the pawn shop. So I think
well, the pawn shop is not it's the person who owned the scooter, which would be Mr. Elatari. That is the actual complainant because it's his scooter that gets stolen, but we just don't know who steals it. We know that he pawns it, right? And we get these so much and it just, the problem is that the legwork would be somehow, okay, we get it, go back to the complaining witness and then somehow see if is there a ring video that sees him stealing it, then, so, right. It is what it is. Mr. Salinas, I'm going to find no probable cause in your case. Please be careful. We're not asking for much. All we want our streets to be safe. You know what I mean? All right, please.
Judge Fleischer found no probable cause because the state offered no specific facts linking Mr. Salinas to the original unlawful appropriation of the scooter. Under the Texas Penal Code, the state attempted to rely on the rule of recent possession. This legal doctrine allows a court to draw a permissible inference of guilt if a defendant is caught with stolen property. However, this inference is strictly conditional. The possession must be personal, unexplained, and most importantly, recent. Texas jurisprudence, referencing cases like Snead versus State, dictates that the probative value of possession diminishes as time passes. If the gap between the theft and the discovery of the property is too long, the possession is deemed legally remote. In Mr. Salinas' case, the scooter was reported stolen in May 2023, but he did not pawn it until August 2024. Judge Fleischer held that this 15-month delay rendered the possession remote, effectively severing the causal link between the defendant and the crime. Without the benefit of the recent possession inference, the state was required to produce direct evidence, such as surveillance footage or witness testimony, placing Mr. Salinas at the scene of the theft in 2023. Consequently, because the state could not rely on the inference of guilt and lacked direct evidence of the taking, the court found no probable cause. The charge was dismissed as the evidence failed to connect the defendant to the actual act of theft. These proceedings highlight why probable cause reviews are such an essential safeguard within our legal system. When a person is taken into custody without a warrant, their liberty is taken away immediately, sometimes based largely on an officer's account. A probable cause hearing becomes the first real chance to evaluate whether that arrest is actually supported by evidence strong enough to withstand judicial review. Judges like Judge Fleischer, who take the time to scrutinize the facts instead of automatically approving the arrest, help ensure that constitutional rights are genuinely protected and that government authority remains subject to limits. When a judge determines that an arrest lacked probable cause, they not only defend the rights of the accused, but also reinforce public trust in the court's dedication to fairness and neutrality. Let us know in the comments if there's a case or courtroom moment you'd like us to examine next. Thanks for watching, and remember to subscribe and share so we can continue encouraging a more informed public.